man. A governor is not a messenger. A governor is a person who is ruling and governing millions of people. It is therefore not surprising that the people in his own area went one man to hear that their governor is being arrested. He is being brought into the country, into the taken by the police. It's quite clear the file was not read at all. Jonah, may I say, draw your attention to the fact that I shall, if I'm given the opportunity, I shall be conversing in some other quarters that the courts have no jurisdiction. You can say the count they have to have the people. There's no jurisdiction in court. And I would refer you to Article 181 and Article 182 in the Constitution. If you read Articles 181 and 182, Your Honor, there is no provision that provides that a charge can be preferred against a governor. The way to deal with a governor is to use the impeachment proceedings that have been provided for in the Constitution. A governor cannot be arrested and charged the way things have been done. The director of the prosecution himself, Your Honor, the DPP has no jurisdiction to make or to prefer charges against the government. So there is lack of jurisdiction. I'm making this point to strengthen my submission, Your Honor, that there is no case against the government. Your Honor, one final question, or one final submission the next year. Please don't misunderstand me at all. I've often thought that in a country like Kenya, strictly speaking, you do not have these rights. You do not have these rights in the law at all. What is required of a lawyer? What is required of a magistrate or a judicial officer is to be strong and to be courageous. The might in you fails that rise to the occasion and show those who are in power, who are in executive, that your powers can be challenged, that your powers can be reduced by the court. And might in you fails that rise to the occasion, the country has gone down. And need young people like yourself, Your Honor, who have got power, to see whether we can bring up and maintain the concept, let the executive keep its own day, not to get into other days. And currently, it is not doing so. Other quotas and so on.
Mahatma.
Yes, there is a book here which we referring to impeachment in the Nigerian presidential system. That's why we have a lot of impeachment of governors and so on. And I've noticed that the order for this book.
What is the title?
You know, I'm taking the title. It's impeachment in the Nigerian presidential system. I assure the very learned senior that we have captured.
Yeah. There's a lot of issues on impeachment they would rather die than have such a government power. Yes, or some people, I'm sure, are swearing that they would rather die than see Governor Natembeya in power.
Very well.
Our father is a father, a profession, he has said it all. Give the governor free vote. At the very worst, so that we don't play in the hands of his tormentors. Let there be no conditions. This man has been elected by his people. He has committed no wrong until that effect. So let's not talk about conditions. In fact, that bridge, is expanded. I plead with you, expand it. Let him get his free vote or cash bill, let him leave. Even we believe, Your Honor, that you do the right thing. We have no doubt at all. I, for one, have no doubt. I know you are a good judicial officer. You believe in the rule of law, that today George Natembeya will walk out. No conditions have been sought and he shouldn't even be there anymore. Let the man go and serve. He'll have his day in court. We thank you.
Ian, I'll start with the jurisdictional issue that has been raised by counsel, especially the very learned Dr. Aminwa, as to whether or not this court to entertain these charges. And that is related to reference, I believe. I haven't made reference, but I believe that's the position. In brief responses, this court's jurisdiction to entertain anti-corruption matters is provided of the ASECA. ASECA is a law. Point of law is ASECA. So this court has jurisdiction. The Director of Public Prosecutions is vested with power to institute criminal proceedings allow me make two. Number one, I don't know whether council read the charge sheet. Count number one is conflict of interest. And not just that. Count number two. How could he have if I don't? In the Republic, unless we are reading different ones. So but even the search in Trans Nzoia was by law. It was sanctioned by law. The arrest was proper. The searches were proper. The to ensure and promote an equal application. Ensure and promote an equal application of the law to everyone. of the law to everyone. Equal application of the law. Article 27, sub-article 4. Equal application of the law. Article 27, sub-article 4 of the Constitution. Of the Constitution. Properly, on the basis of which he could institute these proceedings. He could institute these proceedings before you. I withdraw.
If you have withdrawn, I wanted to clarify that.
I call it different, so I withdraw. Your Honor, back to the question of bond as I conclude. Page 19, reported in the Kenya Law Report in 2010. Republic versus John Kahindi and two others, 2010 EKLR. It is at the footnotes of page 19 of the Judiciary Bail and Bond Guidelines in opposition of bail. Anyone can confirm because the guidelines are available online.
The prosecution
does not need to avail an affidavit in support of an application for denial of bail. While other courts insist on it, not all courts insist on it. That's the import of that decision. It's cited at page 19 in the footnotes. The importance of that argument that we make is that even without an affidavit, compelling reasons can exist. And so that the argument by Mr. Otieno that if certain documents were removed or expanded, then there is no basis There's also the argument as regards saying that we are not.
You can't admit that. No, your pace, not abilities. I'm not doubting your abilities. You underestimated your pace.
We shall leave the court to make a determination. The other thing is that I also hear they may also bring miscellaneous application. I am not sure.
Okay.
Yeah. Remember, the rest have not been arrested, yes?
Not yet, yeah.
Yeah, they are just co-accused.
That's right.
They have not been arrested yet.
Okay.
And they have not been charged.
Not yet.
Neither have they then been investigated.
Yes.
Yeah. So just ask our supporters to continue supporting the process.
That's right.
This is an ulterior case.
Yes.
That is commenced for ulterior motives.
Yes.
With a view of intimidating people to silence. But we are telling them in a new constitution dispensation, at least one of the bare minimum is the freedom of expression. That is the bare minimum.
That's right.
And we shall continue to execute it now.
Yes.
To today, tomorrow, and even in the future.
Thank you, Akili.
And we shall not be intimidated whatsoever.
Asante.
So we expect Senior Counsel Martha Karua is coming.
Excellent.
She'll be the one leading us as a Senior Counsel.
Thank you.
Senior Counsel Karonzo Musyoka will also be
Around?
Will be around, but he's attending his father's funeral.
Okay.
We expect Wakili Eugene Wamalwa.
Yes.
Albert Simiu.
Yes.
Kibe Mungai.
Yes.
And others.
Thank you.
So we have a battery of lawyers to tackle the DPP, and we are equal to the task.
Thank you, sir.
Yeah.
Nimerudisha. Hata funga hii LCD cha nitumie. Nani? Here with him. Ni watu wamesongesha tu, ndio na seti hapa na wewe.
Alafu mwingine anakaa kitu kanaweka nini katika
sasa tutakuwa sauti. Shika hii.
Chukua vitu zenye unataka, nipe bag ndani.
Yes. Unaziita ndio. Hivyo ndio tunafanya.
kama mnakuta mwili toa mwili.
Akisimalize guy.
Weka side
Kwa shoti yangu.
Wewe
Panga alafu ukae hapo.
Waulize tukipanga.
Naomba.
Anaandika. Sikikatika atafanya.
April 24 of 2025, Republic versus George Natembeya.
Present, Your Honor.
A minute.
Walubengo, Waningilo.
Present, Your Honor.
So the last name?
Walubengo, Waningilo. Your Honor, we just been served the charge sheet now. They just get go on record.
Longati, you have not commented about the second.
Kenya shillings 1,127,900 from Mercy Chelagat, the director of Lima Agro Science Limited and the proprietor of Myra Stores, the beneficial owner of Easterly Wheels Limited, which traded with the county government of Trans Nzoia. Is it true or not true?
It's not true.
The payment made by public government of Trans Nzoia to Lima Agro Science Limited, Myra Stores and Easterly Wheels Limited in conflict of your public.
Mr. Jeru.
No, Your Honor, I the petition to purport to put the directions you need.
We believe that because we oppose bail, and bail being ordinarily a right, then this has to go first in an application to oppose bail. Then we'll take the court through the affidavit, the factual matrix. Then we'll take the court through the affidavit, the factual matrix. Allow me to take the court through the legal matrix. And I'll start by indicating that the law on bail is almost application in Article 50, here, sections, and that every arrested person or an accused person has entitlement to bail. And I am normally wrong, so I may be wrong to preempt them, but I promise they will say what I'm telling you.
If you can give,
I promise they will say what I'm telling you.
if you can give them a chance,
The council,
if you can give them a chance,
the council to deliver,
give them a chance.
the council to deliver, just speak for the state which it represents.
A minute.
So to deliver, just speak for the state which it
A minute.
represents.
A minute.
Speak for the state which it
A minute.
represents.
A minute.
The accused has sufficient defense.
Decorum.
Accused has sufficient defense.
Decorum. I repeat. Decorum. I repeat. That time. Decorum.
It is strike law that the denial of bail where there are compelling reasons is not a breach of the presumption of innocence. I trust the court to have a look at Chomley case. I'm not very good with the spelling of the pronunciation of the word. We do not have copies of that authority, but because this court can notice the Tom Chomley case is clear on the relationship between the right to bail and sorry?
And the High Court level or Court of Appeal?
The High Court, sorry, the High Court.
High Court level.
Yes. And therefore that if this court finds that there are compelling reasons, or at least one, Your Honor, because just one compelling reason is sufficient to deny bail, then that does not in any way breach the presumption of innocence. Your Honor, I will also invite you to Article 24 of the Constitution, vis-a-vis Article 25 thereof, on the limitation of rights under the Constitution. And the effect thereof is that the only rights that cannot be limited are the rights under Article 25. And that the right to liberty or any other right that may be alleged to be violated, including the right to presumption of innocence, by denial of bail, can be permissibly limited by dint of Article 24 of the Constitution. The net effect thereof is that a denial of bail where there is compelling reason or compelling reasons amounts to a permissible limitation of a right under Article 24 of the Constitution. Whereas a compelling reason has not been defined by statute in Kenya, we have guidance from the Judiciary Bail and Bond Policy Guidelines, Judiciary Bail and Bond Policy Guidelines, together with several decisions of superior courts in the land, that is the Court of Appeal and the High Court. And Your Honor, that the list provided in the Judiciary Bail and Bond Policy Guidelines is not exhaustive. But without going to the particular facts which my learned senior Mr. Kula is following me to talk about, that list includes as compelling reasons the likelihood of interference with witnesses, the likelihood to interfere with ongoing investigations, and the likelihood to interfere with exhibits. In concluding on the legal issues, the primary purpose of bond is to ensure that an integrity of the trial before you, protection of the integrity of the trial before you. So that, Your Honor, even where it is shown that an accused person shall turn up for trial, if released on bail, we are releasing an accused person on bail will prejudice the integrity of the trial. We are releasing an accused person on bail, even when it is shown that they will attend trial. We are releasing them on bail will prejudice the trial, and therefore the integrity of the trial. This court has a reason, a compelling reason, to deny them bail. Your Honor, a likelihood to interfere with witnesses, exhibits, or ongoing investigations is a high likelihood of interference with the integrity of a trial. That is our submission. Now let me say the last thing on section 8, subsection 2 of the Magistrates Court Act. Section 8, subsection 2 of the Magistrates Court Act deals with the court's jurisdiction, I mean subordinate court's jurisdiction, to enforce Bill of Rights or questions of interpretation relating to Bill of Rights. That jurisdiction is limited to Article 25A and B of the Constitution, the rights under Article 25A and B of the Constitution. It is a clear statutory statement that this court's power to enforce Bill of Rights is limited to the rights under Article 25A and B and nothing more. So that, Your Honor, reference to constitutional provisions as regards Article 49 on bail can only be made in respect of 25A and B. Anything outside of that is outside your jurisdiction, and where you have no jurisdiction, you pen down on those questions of constitutional interpretation if raised. I am honored to appear before you. I thank you and invite my learned senior, Mr. Akula.
And we have filed an affidavit sworn on 19th May 2025 by Mr. Robert Brown. 19th of May 2025, this morning.
Today is
Sorry, yesterday, Your Honor.
That is where I got stuck.
Yes, Your Honor.
19,
We filed this morning.
5, and 5 this month.
Yes, Your Honor. Your Honor, it is sworn by Robert Bono.
Sworn by?
Robert Bono. And EACC forensic examiner. There are the factual reasons or grounds to reject bail are deponed from paragraph 1 to paragraph 12. However, I will cluster them into
Paragraph
three,
1.
to paragraph 12. And however, I will cluster them into three compelling reasons. The first one, interference with witnesses. The second one, public safety. And lastly, the severity of the offense. For the first compelling reason, my Lord, Your Honor, we submit that subject to this case, there are other ongoing investigations. Which at paragraph 3 and 4 confirm that paragraph 3 and paragraph 4 of the affidavit confirm that the accused person, through his agents, the accused person, through his agents, attacked EACC and LPS officers in lawful exercise of their duties. This has been reported and is captured under annexure number R38 at Kitale Police Station. R38, 3R38, annexure R38. Your Honor, we have a next photographs of security vehicles.
With your kind permission, I wish to raise an objection. An objection, Your Honor, is founded on section 106B of the Evidence Act.
That is your name?
Willis Otieno, counsel for the first accused. Section 106. Section 106B
on electronic evidence.
On electronic evidence.
You get your time.
No, I wanted to raise an objection because it's time to refer to it.
You get your time, let it continue.
Also, we have a next
I want to conclude the direction.
series of photographs marked as RR1 to RR37.
1, 2, R,
37. Your Honor, those photographs depict vehicles belonging to EACC, National Police Service, that were vandalized at the residence of the accused person. Yesterday, when the officers were executing the lawful mandate.
executing
The lawful mandate. That is, doing a search pursuant to miscellaneous application E716 of 2025.
Come again. Miscellaneous application number
E716
E716
of 2025. That is deepened in paragraph number 4. You know, photographs RR3 to RR10. RR3 to RR10. They depict motor vehicle KCH 046T.
come again. 0
46T. After it had been vandalized. Then our photographs R11 and 12 depict KCB 628X. Photograph R11 KBU 734Y. And photographs for U ACF 541U. At paragraph 7 and paragraph 8, the officer deposed. At paragraph 7 and paragraph 8, Mr. Rono deposed. In these vehicles, important documents were taken. Now we take judicial notice of the position of the first accused. The witnesses in this case, Your Honor, upon disclosure, are his subordinates. People employed under his government. What is the test of interfering with witnesses? It is not beyond reasonable doubt The test is just a reasonable prospect that the accused may chamber with the witnesses.
The test is?
A reasonable prospect that the accused person may tamper with the witnesses or the evidence.
Perhaps, and I'm aware of the directions you've given about the deferral. Perhaps we need your guidance whether counsel can go outside the content of his affidavits and claim to bring averments that are not contained in the affidavits, because that will prejudice us in terms of our response. Because there is no averment in the affidavits that affects that the proposed witnesses are the subordinates of the government.
I'll give the guidance again. Wherever you pick along the way from both submissions, kindly bundle them together. Once you rise, I expect that you address all the issues in one sweep.
I wonder.
But let me record you first. Spectacular witness concern. I need to record his objection. Everyone,
I will repeat your knowledge.
How long more? I thought we were going to take 3 minutes. Now we are going to will we sit here the whole day? Just off the cuff. How long more?
I'll tell you. Just summarize this.
10 minutes.
Yes, sir. I will repeat that.
You have 10 minutes.
We are submitting that once disclosure is done, the witnesses will be calling our officers from the first accused country. Those are disappointed. I'll go to the second limb, severity of the offense. I'll go to the second compelling reason. When a perusal of the charge sheet, the amounts will appear casual.
The amounts will appear?
Minimum 1 million. But we believe Your Honor will win this case. And we'll draw your attention to section 62(1) of ASEC. 62(1) of ASEC. In the event we succeed, that provision is very punitive.
In the event?
We succeed.
We is the
DPP.
The DPP.
Prosecutes this case. We get a conviction.
If he is successful.
Yes. We will be moving to section 62, subsection 1. And you know that the severity of corruption cases, for someone to interfere, is subject to the positive. Lastly, I've alluded, Your Honor, to what transpired yesterday. And I've said that investigations with regard to other cases are ongoing. Our submissions is that if we release the accused person today, what transpired yesterday will occur. And we are apprehensive that in the interest of, in order to protect the integrity of the criminal justice processes, a plea bailing court will bring before this court and decide on this matter. That will be a
Sorry, Your Honor. Just to underline that our prayer is that the first accused be denied bail. That probably is the last sentence you have done. Thank you.
How many of you
please, I'll take the first one.
Because I listed, how many? Listed 11.
Yes, and one. Not all of us, certainly.
So how many? Just to manage our expectations.
About five. About five or up to three. We do it on the line. We don't want drama, we just want to go to the issues. Because the issues are straightforward, Your Honor. But let me start by introducing Senior Counsel John Kaminwa. He's our guide.
I'm here, Your Honor. May I say good morning?
Good morning. Karibu.
So we have an opportunity. Then Aaron Dubi is also here.
So that is
Aaron Dubi. Your Honor, let me be the first one to just give some. Let me at the outset state that the prosecution is causing unnecessary drama in an otherwise straightforward matter. And our focus at this point should be the rights of the accused person, who remains innocent unless and until he is proven guilty. So no amount of reasoning. Yes.
Yes.
So no possible grounds can be advanced that can be directed at taking away the accused person's rights. That should be the starting point. And there are some case, Your Honor, as a counsel,
It
is factual. It is factual.
The right note.
When we
but
purport,
I'm sure Dr. Hamino is smiling at you.
when we purport,
I'm sure Dr. Hamino is smiling at you.
in fact, I'm one of the few who have the advantage of having interacted with you in my previous position in JSC. I know you have a very sharp mind. We don't need to come here and start the previous position in JSC. I know you have a very sharp mind. We don't need to come here and start citing to you positions of law and affidavits. So I cannot, by any stretch of imagination, expect that a court.
I'm making a backup for the.
Yes.
We don't trust technology.
The technology.
I'm making a complete backup for technology. You can continue.
So I dare say, Your Honor, that even the prosecution, because they're also lawyers, we all pass lawyers before we are.
Sorry, Your Honor. I know the court warned us of decorum, but we plead. I am just 12 years in practice. We plead that senior Masharia doesn't get personal.
There is a special reason, Mr. Njeru. I did what I did to your side. So that we remain focused.
With tremendous respect, what we have here is lawfare, which I urge you, Your Honor, to take judicial notice of, because we live in this country, we are interacting with social media, we know what is happening in our country today, and none of us can purport independent agencies are being captured and being used to weaponize matters of justice. That's what lawfare is all about. We use legal processes to attain an ulterior objective. Your Honor, I'll make a confession to you. I was, and we shouldn't allow it. Your Honor. I'll give the context. I'll give the context. I'll give the context, Your Honor. Yes, I'll give the context.
Focus here, Mr.
The context. I'm not here to talk about where I was and
Sorry, Your Honor.
It's just to indicate.
Sorry, Your Honor, we are forced to object once more on the question. The factual matter is that, with respect, he cannot tell us from the past. We would believe him, and I know he's a very truthful man, but for us to believe what he's telling you to believe, let him give us an affidavit of those facts so that we're able to respond to those facts. Without that, we humbly plead again. We humbly plead that he gets back to the case and not tell us the other things that are factual and there's no affidavit. We plead with him. We understand that he's previously the commissioner, we understand. But let him get back to our case. Thank you.
Look at the affidavit.
A minute, Mr. Njeru. I complete recording.
Your Honor.
Mr. Njeru, your brief response, you're responding?
They've made general averments. To start with, problem number one, they serve us in an affidavit this morning. We expect us to make an application for adjournment so that we can file an affidavit. And in the meantime, the accused then the affidavit itself is marked with general averments. Not respondents agents, they are not naming which agents.
Oh, just to be clear, you responding to the objection or you continue with your submission?
I'm responding to the averments, yet in his own affidavit, he has made very general averments that are in support of denial of bail. Then he respond to that, at least from the back. At the very least, that should be expected. He can't have a steak and eat it. The subject of these proceedings is the accused person. The rest of us are speaking here, and then we'll walk away. But this is the subject. That's the person you should focus on.
That is the issue of the table. Continue, Mr. Diego.
Much obliged, Your Honor. No. Including very sensitive security agencies. And he also understands the law by his own right. He understands his obligations to the public security. In custody for this kind of charge. Why? It can only be for, and it is that desire to continue punishing you that is driving the application for you to be denied bail. You cannot allow yourself to be used. I have consistently said that the last line of defense for this country, the only one remaining, Your Honor, is the judiciary. And let's not think. So regardless of what happens here with these protracted submissions and responses and counter submissions, not fall under the trap of saying that you're going to write a ruling another day. In the meantime, he remains in custody. Don't allow this man to remain in custody. He's already been punished enough by being put in custody, even for that one night, when he could have been summoned to appear in court and he never appeared. One of my colleagues here will speak about the facts, then Chesa, but I can tell you, Your Honor, the reality of our times is that between now and 2027, these are the kind of things you're going to see continuously. I plead with you, do not fall into that trap. I'm confident you will not do it.
Thank you. Your Honor, just to associate myself with the submissions made by Milimani Senior, drive the mischief. that the accused person is currently...
Slower. Pause after every sentence.
Is charged before you with another person, Wafula Masungo, who is not before you. It is not that Wafula's whereabouts is not known. It's because Your Honor, to perpetrate this mischief. In almost for explanation, Your Honor, my lad senior indicated that he was seeking summons. It's the same mischief, Your Honor. The opposition, Your Honor, was that you seek summons. Was not indicated to you. That is to say, must be read in light of that mischief. That other than pursuing other ulterior motives that are politically actuated.
Apologies. Redirected. Colleague is submitting on a fact. Unless he has evidence as to what he wants to speak about, we would ask him to take the rights of the accused person. Let's not impute ill motive to anybody unless they are willing to test the dog in the very
is contained in the affidavit filed by the ODPP. That's not surprising, Your Honor, that the affidavit contains it has no tangible evidence that proves to the contrary. If I was to proceed, Your Honor, in response to the substantive application,
must give direction on the objection. Belong to the law of God and will, avoid instances which may persuade me to request for fact.
The affidavit contains mere speculations. There is no averment in the affidavit.
After every sentence,
before you, the averments in the affidavits have no nexus with the charges before you. Neither the prosecution, nor the defense, nor the court are privy to. Would be tantamount or will amount to violating his constitutional rights. And most importantly, the right here witnesses are subordinates to the governor, the accused person. Again, it is not contained anywhere in the affidavit. If has no probative value of whatsoever nature, and the accused person. And as such, that cannot be considered to be a compelling reason. More annoying, Your Honor, more of KCH 046T, it will not tell you the registered owner of KAE 738F. It is guided by the Registration of Motor Vehicles Act. And if you are courteous enough, as I pen off and invite my learned friends, to draw your attention to the charge sheet once again, that there is no charge where there is a charge of conflict of interests. At Article 50 in isolation of Article 25, in light again of Section 8 of the Magistrates Court Act. From Article 25, he tells you that the question if you look at the Black Laws Dictionary, Black Laws Dictionary, it will give you as to what is deemed to be compelling. No evidence produced. No law produced. No law quoted. No case law. The integrity of the proceedings. Will not affect the so-called pending investigation open society. I invite Mr. Jero to guide us on who next. Thank you, Your Honor.
Another we understand the implication, right?
We understand.
So you cannot submit the whole day and expect magic. We should be reasonable, and they say, for wise Chester, I'll give you 5 minutes.
Very well. Your Honor, I want to start by raising an issue and Section 8 of the Magistrates Court Act gives the authority to see what search warrants, not such warrants, which they abused by literally and Nairobi bungling him into a police vehicle, bail, to deny bail. The High Court must provide cogent, the term that is cogent evidence, and he keeps referring to some ghost creatures called agents of the respondent shouted at Integrity Center. And that's a very serious threat. They have not drawn the matrix to the so-called agents. Was it Governor Natembeya's wife? Were they governors? And this court must not listen to them. The accused person, your honorable servant, he is Natembeya County. He is a deputy party leader. At the time, the so-called ghost agents were shouting, he was only one advocate, Mr. Simiu. The rest of us were locked out. The court said that the seriousness of the offense,
I repeat, 1-1 is enough.
Lastly,
I don't know why we get this temptation. As the more I speak,
the High Court at Nairobi, criminal case number 48 of 2016, actual witness interference.
That indeed, as at 6:30 a.m. yesterday, the accused person had lost by Mr. Robert Rono is certainly not accurate. Number two, Your Honor, the place where they went to play Milimani residence. That is repeated at the order that they received to search the accused's premises had the following residences: Kibomet.
come again.
First is
No, the second.
second is a place called Kibomet. Kibomet. Third is Nairobi residence in Kileleshwa. Okay. Were vandalized when they were searching his Italian residence. Your Honor, looking at the order, which Your Honor you can have a look at. And therefore, Your Honor, we are appealing to you that the evidence that has been annexed to the affidavit is illegally obtained. 5. To the Evidence Act, Section 106, capital B, Section 4, subsection what?
You're on the 6th minute. The 6th of minute.
I wrap up here. Please refer to the documents.
You read it reason.
I yield, Your Honor.
Honest to the court.
Thank you.
Your Honor, I'll try to take 3 minutes at max, and you stop with 5 minutes. There is no certificate of electronic evidence annexing those pictorials. By dint
Slow. You left me a mile ago. The applications contained in
and in the absence of the electronic certificate, the annexures, Section 3 of the Judicature Act, list the sources of law in Kenya that this court is called up. When we say the court to apply Article 49, to apply Article 50, we are asking the court to apply remaining constant. The right to bail is constitutional. And the purpose of giving terms is to compel attendance. Detention should never be used as a basis to punish an accused person who is still presumed to be innocent. Thank you.
Mr. Njeri, your last soldier. Your
Last
last
thought. This one, and then Dr. Hamino. Then we are done.
Dr. Amino.
Thank you, Your Honor. Your Honor, I'm very privileged to appear before you to demonstrate that what I did recently in my second PhD in criminal justice. I would like this court to look at the whole history of the government and intergovernment officers calling themselves ES law, whereby if the government raises its own legitimate expectation, if that was the case, then that law must be narrowly, and I mean narrowly, tailored. How do we look into the classification of what the state has alleged? Classification, looking at the time to drive, the time taken to drive the accused, the miles involved in that journey, and how the accused was arraigned in court. Lastly, and please let the court make me understand, whether the arresting officer is the investigating officer and is the judge, and even if that statute contradicts the Constitution, in which case I believe it does, following the circumstances. I think it should, because I can substantiate it. Your Honor, what I mean by literacy is not literary. It raises issues that can only be raised on discovery. Thank you.
My running friend is Sundupi. I always appear with him in the cases. He had only one word that he wants to tell you. Only one word.
One word will take maybe 1 minute or less. First, we look at the charge sheet. Particulars refer to one. It is impossible to tell which one they mean, except for the use of the word God. Related to that is the particulars in the charge sheet under the law. I make the presumption that the court knows how to do that, right, and understand those particulars which are suggesting that he has committed an offense of corruption, of conflict of interest. The particulars of conflict of interest have not been indicated. So that's what speaking is. If you look at count 2, the same problem of lack of particulars. So there is no evidence that demonstrates. We were told monkey see, monkey do. When the government itself regulates court orders, citizens have no reason to. I do recall off the top of my head the governor of Istanbul who was charged with does not stand. The court has authority and discretion to give conditions that will ensure that the proceedings of this court are.
Because several counsels or advocates have spoken, they have made personal submissions. I would respectfully argue that tell the audience that a written ruling will be delivered much later. By the High Court. This has already been done by the Court of Appeal.
This one?
Giving reasons later.
Yes.
Has always been done by the Court of Appeal that the governor is released forthwith and you will deliver the ruling later. I also urge you very, very respectfully to listen to the nation, and there's no way you can be in Kenya or another country at home. Give them a free point. And you will also be etiqueting certain people and certain people, saying to you respectfully that you make an order before you rise.
Sorry, that is called, and it's
that the governor should be released on a free bond.
You're a child?
Born in the colonial days.
Colonial days.
I'm the child who received education in colonial institutions. Of sociology, anthropology, philosophy, when we had terms like the African mind, how the African thinks, and so on, from the colonial days. There's one thing I can make you very clear. The criminal law of Kenya has always been during the colonial days. It was abused during Mzee Jomo Kenyatta's days. It was abused during the Patrick's reign.
I think the statement is home, Dr. The statement is home.
They have now taken over the criminal law of the country. They are abusing it. The rule of law which we thought was improving is now in ICU. That unless we arrest the situation, nobody will have confidence in the country. The country could easily be classified as that it can come.
Daktari, if we can deal with Mr. Natembeya first.
Yes. Your Honor, what is the charge that you are given here, one can even pass with laughter. The past comes. The governor is supposed to have corruptly received the sum of shillings. One can see that this is dishonesty. The country because of that amount of money. That's on the first page. What is that? A full governor, 2 million, 168 shillings. Thirdly, Your Honor, we're letting a point clear. A constitution not be meaningful, it must develop something called conventions. In some cases, something called conventions. You would expect that a charge against a governor of the country, the director, to satisfy himself that a case has been made out against Natembeya. Having regard to what was being told, it was realistic to it. When did the DPP read the entire file? At least if I may say in favor of Charles Johnson, he would read the entire file to satisfy himself that indeed a case has been made out to millions of people. It is therefore not surprising that the people in his own area were mad to hear it read at home. Your Honor, may I say, draw your attention to the fact that I also have no jurisdiction to entertain the count that they have the document placed before the court. There's no jurisdiction at all. But a charge can be prepared against the governor. The way to deal with the governor is to use the impeachment proceedings that have been provided for in the Constitution. The governor, Natembeya, release him Donna, one final question, one final submission and the next to you. Please don't misunderstand me at all. What is required of a lawyer? What is required of a magistrate or a judicial officer is to be strong and to be courageous. In your very respectful, that rise to the occasion the country has gone down. And you need young people like yourself, John, who have got power, to see whether we can bring up and maintain the concept. Let the executive keep its own way, not to get into other days at all. As currently, it is not doing so. Other quotas and so on.
Mahatma.
Yes, there is a book here which we referring to impeachment in the Nigerian presidential system. That's why we have a lot of impeachments for governors and so on. And I've noticed that the order for this book.
What is the title?
You know, I'm taking the title. It's impeachment in the Nigerian presidential system. I assure the very learned senior that we have captured.
Yeah, there's a lot of on impeachment they would rather die than have such a governing power. Yes, as some people, I'm sure are swearing that they would rather die than see Governor Natembeya in power.
Very well. Our father, the father, the profession, he has said it all. Give the governor free board. At the very worst, so that we don't play in the hands of his tormentors. Let there be no conditions. This man has been elected by his people. He has committed no wrong until that effect. So let's not talk about conditions. In fact, that date, you want to please expand it. I plead with you. Expand it. Let him get his free vote or cash bill, let him leave. Even we believe, Your Honor, that we do the right thing. We have no doubt at all. I, for one, have no doubt. I know you are a good judicial officer. You believe in the rule of law, that David George Natembeya will walk out. No conditions have been sought, and he shouldn't even be there anymore. Let the man go and serve. He'll have his day in court. We thank you.
I'll start with the jurisdictional issue that has been raised by counsel, especially the very learned Dr. Amino, as to whether or not this court to entertain these charges. And that is related to reference, I believe. I haven't made reference, but I believe that's the position. In brief responses, this court's jurisdiction to entertain anti-corruption matters is provided of the ASECA. ASECA is a law. Point of law is ASECA. So this court has jurisdiction. The Director of Public Prosecutions is vested with power to institute criminal proceedings allow me to make two. Number one, I don't know whether counsel read the charge sheet. Count number one is conflict of interest. And not just that. Count number two. How could he have... The second correction, Your Honor, my learned senior, Mr. Masharia, if I don't situate it within the Republic, unless we are reading different ones. So that even the search in Trans Nzoia was by law, it was sanctioned by law. So the arrest was proper. The searches were proper. To ensure and promote an equal application, ensure and promote an equal application of the law to everyone, of the law to everyone, equal application of the law. Article 27, sub-article 4. Equal application of the law. Article 27, sub-article 4 of the Constitution. Properly, on the basis of which on the basis of which it would institute these proceedings, for you. I withdraw.
If you have withdrawn, I wanted to clarify that.
I call it different. So I withdraw. Back to the question of bond as I conclude. Page 19 reported in the Kenya Law Report in 2010. Republic versus John Kahindi and two others, 2010 EKLR. It is at the footnotes of page 19 of the Judiciary Bail and Bond Guidelines in opposition of bail. Anyone can confirm because the guidelines are available online.
But the prosecution
does not need to avail an affidavit in support of an application for denial of bail. While other courts insist on it, not all courts insist on it. That's the import of that decision. It's cited at page 19 in the footnotes. The importance of that argument that we make is that even without an affidavit, compelling reasons can exist. And so that the argument by Mr. Otieno that if certain documents were removed or expanded, then there is no basis There's also the argument as regards bail that we have not.
You can't admit that in. You can't admit that in. Know your pace, not abilities. I'm not doubting your abilities. You have estimated your pace.
Thank you. Yona, I was referring to. Did I say last? Kindly.
Last, you were attacking the challenge by Mr. Otieno.
All right, yes, thank you very much. So, Mr. Otieno was of the effect that if there is no certificate under 106 Aminwa, in Mr. Ichesa's words, the first accused is a governor of a country, and he is not a lonely man. Verbatim, if I got it right. Objecting on, is it points of law or what you say?
As in, you have quoted my statement in my presence.
Yes.
You clearly misunderstood it, and you want to go to the next person without clarifying the question.
Sorry, Your Honor, I have not wrong in my interpretation, but in hearing you, I can't be wrong.
Points of fact, points of law.
Your Honor, I'm coming to the point of law. I'm still quoting him. You cannot be the point of law. I am coming to the point of law. And thirdly, I am reminded that my very good friend, senior Dr. Ndu, that the influence of the first accused is admitted by his counsel on his behalf, and that it is not far-fetched that of the judiciary bail and bond policy guidelines talks about likelihood. Yes, sir.
You should have said you need that.
I am done. That is my last point. Influence, there is a compelling reason you must deny bail. And standard of proof is on a balance of probabilities. I thank you for being patient with me. I am such a mouthy, and we urge you that we have established compelling reasons to deny the first accused bail. Thank you, Mr. Your Honor.
Your Honor, the Commission, could you add one of my colleagues who came in late? Honorable Jeremiah Kioni, for counsel, who will listen on record. I will now be able to come to good right here.
It's now taking these for a while. You are ruling on the matter. I possibly need one, we take a lunch break. Take a lunch. So the issues are into millions. I will try the best to do it in 1 hour. And Dr. Haminwa encouraged me to. Unfortunately, we have not been facilitated that way by our procedures. For the Court of Appeal, for the Supreme Court, they are facilitated properly by that actually can give ground of my abilities and competence, which I do not wish. So we take a break. We resume at exactly 2 for the ruling. Much of the ruling.
morning. Welcome back. You're still watching Daybreak on this 20th day of May 2025. In studio I have Geoffrey Wandeta, who is the Member of Parliament for Tetu constituency. I also have Kabala Kile, Deputy Chairperson of PLP Party, People's Liberation Party, right? Great. Senator Veronica Maina, nominated Senator of the UDA Party, the governing party, and also Professor Maxwell Miyawa, International Development Laws.